Good day and welcome to another episode of Strictly Legal on WESN Content Capital. I am Rondell Dono, attorney at law, and I am happy to be back. I know we had a short break from the show, but we are back and we are ready to begin our new episodes. Of course, you can stream us on our social media platform, WESN CC, podcast, Strictly Legal with Rondell Donwa, and of course, our traditional media. Getting right into the program, we are dealing with publicity in negative publicity in criminal trials. More importantly, the impact of delay and media publicity that is, and how negative or what type of impact it has on fair on having a fair trial, or the accused person having a fair trial. And of course, I have on set again attorney at law Farid Ali. He is probably the most frequent guest of mine, and that is because of his wealth of knowledge, as well as we are continuing the conversation from, I know we had the last episode of evidence in trial, and we are going to continue the talk on evidence because it's very important, particularly as it relates to a lot of time we're seeing that persons are using camera phones, persons are speaking about trials publicly because we are incensed by crime. And of course, persons feel as though detection rates, I know we would have spoken previously, detection rate right now is approximately 18%. So because of this, persons want to see justice. And whether or not publicity or whether or not pre-trial publicity is fair to the accused. And I will bring Mr. Ali on set now. Good morning, Farid. How are you?
Good morning, Mr. Donovan. It's a pleasure to be here. It's good to see you.
And thanks for coming once again. I know you answered that call, and we are really grateful for that. Of course, I know on the last episode we dealt with evidence. We dealt with the trial process, the criminal trial process. What is preliminary inquiries? What is a summary trial? What is indictable? And of course, leading on to that, I want us to discuss more particularly with pre-trial publicity. I know we would have mentioned it very briefly, but I want to get into more detail as to why is it that pre-trial publicity can negatively affect the justice system, or rather the accused person being treated fairly at trials.
Right. If we were to consider the Constitution of Trinidad and Tobago, the Constitution of Trinidad and Tobago speaks under Section 4 of one's right to a fair trial and a fair hearing. That is captured essentially in Section 5, subsection 2F of the Constitution, which speaks to every accused person, everyone who is before the court. That individual is entitled to a fair trial, a fair hearing, and they are also entitled to the presumption of innocence. The presumption of innocence is simply this. When you come before the court will treat you as an individual, an accused person, as somebody who is innocent until the evidence proves you otherwise, or proves you guilty.
Indeed.
So the thing with pre-trial publicity, when it is you have these what we may call high-profile cases, we have serious criminal matters that the public may have an interest in. If we look back into our history, we have a very colorful history in this country where persons were brought before the court who had a reputation before they were actually charged for the particular offense for which they're answering. Some prime examples of that would be the Yasin Abu Bakr. He was projectively the leader of the Muslimin.
Yeah.
And in 1990, there was an attempted coup. So by the time he gets the trial, for whatever matter, that reputation of being the leader of the Muslimin movement, that precedes him. One of the most notorious ones and the more popular ones in this country would have been the one that is associated with Nanki Sin Budram, the person who is commonly referred to as Dolce D. In 1994, there was a very popular, very famous criminal case born out of the fact that it was alleged, and I am saying it is alleged because we're taking it in the context of the matter hasn't started. It was eventually ruled against Chedi. The court ruled that he was guilty in terms of the jury found him guilty. But Chedi had an issue with the fairness of a trial in Trinidad and Tobago. His reputation as a known drug leader and as a known conspirator in terms of criminality and persons who were involved in the drug trade never really allowed for him to be viewed in the eyes of the public as somebody who is capable of any good. So the issue that arose in his trial process was simple. He is saying that he could never get a fair trial in Trinidad and Tobago because the persons and citizens of this country view him in a very negative light. What transpired out of that is the newsprint in this country carried a number of editorials highlighting what they consider to be his disreputable conduct and things that he was associated with in his mind that were untrue.
Yeah.
So that really touches the heart of pre-trial publicity. What was carried in some of the newspapers and the articles reflect, and I'm just giving you a very, very brief outline. It said, one article carried that top US diplomat in Coke scam, and this was carried on the front page of the TNT Mirror in September 1994. Some of the other things that were carried in the Sunday Mirror was he was a convicted drug dealer. Telephone calls were made from a cellular phone from his cells, calling hits on other persons. So though he was the subject of this particular trial, he was arrested on occasions before, and every time he was arrested, the witnesses in the matters who were offering evidence against him would disappear.
Let's take a pin. But can't the media now argue, of course, freedom of the press to inform the citizens as their charter states?
The Director of Public Prosecutions has a role to play in every criminal trial.
Yes.
He has a dual function. His function is not just to carry the evidence in a courtroom and lay the evidence before the court, but his function is also to make some input in ensuring that the streams of justice isn't polluted and isn't contaminated by the work of the media. In other words, the balance between freedom of the press being able to carry certain things and say certain things concerning the editorial around their story. The Director of Public Prosecutions, can step into that arena and write to the media houses, get involved in terms of inform the media that you can only carry so much, and to be very, very careful about what you put in newsprint, because when readers out there read about what the media is telegraphing to them, or they listen to what they're hearing on social media, or they listen to what is being said, they begin to relive and to exist within the narrative that is being carried. So the balance that has to be carried is whether the director should get involved before the trial starts and try to constrain what is put into the public space concerning an individual or the facts of a matter. That is why it is very often lawyers are said not to try your case in the media, not to go out there and start representing the interests of your client, offering information that amongst nearly evidence. And you're leading your evidence through newsprint and through social media and through YouTube and television and books and any form of streaming.
Yes.
So the director could simply call out on the attorney and said, listen, this matter is before the court. You should not be carrying any storyline, reading any byline. And it was ruled that balance between fair play, that balance in order to achieve fair play between freedom of the press and the role of the DPP to control what comes into public space must be established very early. However, what we got in the Dole Shady matter, what happened in that is very simple. There was the Babulal family, 4 persons met their demise. The story simply carried forward indicated that Dole Shady called a hit on the Babulal family. Yeah. Gunmen turned up at his house, 8 gunmen, and having turned up at the family's home, there were 2 persons who turned state witnesses, Clint Huggins and Levi Morris.
And we know what happened.
Both of those individuals turned state witnesses, and they offered evidence for the prosecution against the Gang of 8. And what evolved out of that situation is that they were saying that Dole Shady organized the entire episode. He was the conspirator. He's the one who planned the episode. And the men turned up in those days in 1994 with two 38 guns, 244 and 2 9mm. Now in modern times that's jokey weapons, but it was serious weapons in that context. Mm-hmm. Now, simply put, the Shady's defense team involving senior counsel Frank Solomon and Desmond Alum, they offered to the court that there should be a stay of prosecution. A stay of prosecution is where the trial process should be stopped, because we cannot get anybody willing to stand before this court in terms of jurors who are willing to put their lives at risk, given the fact that there has been rumors that everyone or most witnesses who have offered evidence against this man in the past met their demise, and it was alleged that he was responsible. So what the courts of Trinidad and Tobago, the judiciary did, is they set up a court in the Northwestern Peninsula in Chaguaramas. Separate witnesses were airlifted into the courtroom situation, and the trial process began. This began somewhere in around July 1996. There was a verdict by September, but the process to vet the jurors was an extensive process. Amendment had to be done to the Jury Act, because many jurors expressed qualms about being able to offer themselves and to be unbiased.
And of course, you have the law when it comes to the Jury Act, that there's only certain exceptions that will disallow a prospective juror from participating in the trial process.
Right. And this is all part of the ruling of the court. This matter went all the way to the Privy Council. The Court of Appeal made a ruling in terms of whether he can get a fair trial. The Court of Appeal said that he can get a fair trial in this country. They went to the Privy Council in appealing the Court of Appeal's decision, because Shady was insistent that he couldn't get it. What the court is saying, the best constraints and the best control mechanisms that are in place to ensure that fair trials persist in this country would be the criminal court itself. So it starts from the jury section. When the jurors are being selected, the prosecution and the defense has an opportunity to vet the jurors, to ask questions of them whether they think that they offer a reasonable verdict in this. And if it is at the end of the process, we can find 12 persons, and we did in this instance find 12 persons and 8 alternates. The trial process proceeded. It also meant that the judge has a part to play. He can direct the jury when they're going to deliberate on a decision, and tell them very, very succinctly that you need to separate yourself from the editorial, from the innuendo surrounding the individual, and allow yourself to make a decision purely based on the evidence. So pre-trial publicity it's important to recognize that the control mechanisms essentially lies with the court. The Privy Council ruled that though the Director of Public Prosecutions in the case of Dolchidi didn't directly get involved and put control mechanisms in place in terms of instructing the media what they can and cannot carry, it doesn't in itself prejudice the ability of the court to manage and regulate the evidence in the courtroom, so much so to control the jurors on the level of imparting to them the need to separate themselves. So in order to achieve a fair trial in any criminal court, you need the input of the Director of Public Prosecutions before the trial starts. You need the cooperation of the media in terms of not carrying the facts of the matter, and you also need the attorneys in the matter to not try the matter in the media, because defense attorneys tend to do anything to generate sympathy towards their client.
Of course, and of course, you know, everything is leaked to the media. Everything has to be posted in the media's forum. And let's look at, okay, this was 94. Moving forward now, we also have an issue, of course, with the delay in the criminal trial process. Yeah. I mean, you mentioned that a verdict was trial started in July in the Dolchidi issue. Verdict got there was delivered by September, right? And now we have the issue of delays, constant delays in the criminal justice system. I know the judiciary would have done a lot of different things. Legislation were amended in terms of bypassing preliminary inquiries or having judge-alone trials. But yet there are still persons that are in remand for more than 15, 20 years. Let's touch on that issue. I know we have spoken about it on previous forums, but let's touch on why it takes up to 10 years for an accused person to go before a trial, well, judge or jury.
Right. Well, perhaps you could just look at some stats, just to start where we are. On the 7th of October 2020, the Chief Justice had indicated that in the year 2019, the criminal court was able to dispense with 12 indictments. 12 indictment means that there were 12 trial processes, criminal trial processes in the year 2019. But he was indicating that though they were able to achieve same, there were 1,706 cases that are before the High Court for trial processes, but they couldn't start the trials. And of the 1,706 cases, 960 of those matters have been delayed for a period of 10 years. So the problem we were having is simply that we have too little number of courts in this country to absorb the levels of criminality that is taking place. In other words, there's more crime taking place, so crime is taking place at a faster rate than the courts could absorb and ventilate all these issues. So in dealing with delays in the justice system, what one needs to understand is that the court itself could only do so much. With the introduction of the criminal procedure rules, the introduction of the judge alone trials, these are mechanisms that the court has taken to eliminate the need for lengthy trials. When you have juries making decisions in a matter, they are arbiters of fact, they're determining a person's innocence or guilt. It is the perception that a jury may take longer to absorb the information, to be able to process what is happening, and in order to come to conclusions in matters. Sometimes when you have a judge alone making a decision, meaning the judge rules on facts and rules on law, the process in the courtroom can be a lot faster. The thing with delays is it is difficult when you have an administration of justice that is slow, because of a lack of courtrooms that could treat with the matters, and a lack of personnel to deal with everything, to push, and especially when in cases, as we said, that we have a total of 1,706 cases backlog.
Yeah, but what about the fact that the DPP's office, or even the prosecution, whether by virtue of witnesses and stuff, they are never ready to proceed? You know, because a lot of times you find that the delay is not really on the defense side, but on the prosecution side. Right. And justices or magistrates will continuously adjourning. Yes, giving stern remarks on the need to speedily deal with the trials, but at the end of the day, let's touch on that.
Right. It is carried, and it's public knowledge that right now the Forensic Science Center has to analyze 100,000 guns in terms of determining whether they are forensically or scientifically proven to be guns. When it is somebody comes before the court, it is often described as an L-shaped object resembling that of a firearm. But for something to qualify, or for an L-shaped object to qualify as a firearm, it must meet certain requirements. It must have a trigger, it must have a barrel. And sometimes if a gun comes before the court and it has not been properly analyzed, it remains an L-shaped object resembling that of a firearm. It doesn't. The court must have an analysis done of the weapon. But when it is you have 100,000 of those weapons to be analyzed and one forensic science center, it is from the administrative side, the prosecution finds itself hamstrung because they cannot proceed with a trial, even though they may have statements from witnesses, even though they may have the file as it pertains to the police complainant and the police witnesses and the civilian witnesses ready, and they're prepared to begin a trial. One of the major delays is if the crime involved a firearm, and very often now we see a lot of crimes involving high-powered rifles, AR-57s, 9mm weapons, and until this analysis is complete, then the trial process is delayed even from the Forensic Science Center end. So what we're seeing here now is apart from the delays within in terms of backlogs over the years, and people joining the queue. So a man in 2022 is joining the queue behind somebody who's been waiting since 2015. We have delays in terms of the administrative and in terms of the forensic evidence is not it's not ready. It applies to marijuana, it applies to cocaine and drugs. It takes years for sometimes these items to be analyzed, and if it is not analyzed, and we don't have certificates that reflect that scientifically the L-shaped object is in a gun, the plant-like material is marijuana, that in itself delays things. Indeed. So delays in justice is hinged to that sort of thing.
But then we're looking at also delays in terms of, yes, we have the disadvantages in terms of fair trial for the accused, but then what about the issue of witnesses dying, witnesses' memories being faded, and you know, all these various things that will infringe and obviously will be at an advantage to the accused person.
Right, and all this ties in, delays ties into fair trials. When it is we have a matter delayed 10 years, and the witnesses that the defense may wish to offer, who may be offering something to strengthen his case against what the prosecution is saying, meaning you may have an alibi. Your alibi might be able to say, well, I could not be killing somebody in Tunapuna when it is he was in San Fernando in Gulf City with me. So the witness not being able to be present to 10 years down the line may simply deprive that man of a fair trial. And it works vice versa too.
Right.
The prosecution may find themselves short of a witness. They might find themselves in a situation where it's been 10 years, the witness that they're going to offer has died, he is ailing, he has moved abroad, he simply may be fearful. There are any number of reasons, and what results as a result of that is we're unable to get the result that we need. We're unable to get a fair trial. We're unable to fully ventilate the facts in the trial because of the unavailability of a witness for different reasons. And delays are a direct result of that. Delays also are affected when you have, from the criminal justice side, the victim is afraid to come and give evidence because it's been 10 years. It would rape victims. When they wait 10 years, in order to get an opportunity to offer their evidence. Some of these women, they are married, they move on in their lives, they have partners who they've never shared their rape experience with, the sexual violation that they went through, and they're simply not interested anymore in offering any evidence. So when we have delays, the delays work for the prosecution sometimes, and it works against them. We have to look at the issue in the context of time and space. And justice isn't served when justice is delayed. Indeed,
and justice delayed is justice denied, right?
Yeah.
And obviously, what sort of, I mean, yes, we dealt with the impact, but then does that mean that there may be mistrials because of such delays or whatever varying obstacles that may be in the pathway of administration of justice?
Well, what can happen is simply this. And we need to look at probably it from a constitutional point of view. In Trinidad and Tobago, we don't have in this country the right to a prompt trial. We have the right to a prompt hearing, and a prompt hearing is different from a prompt trial. A prompt hearing is where once you've been arrested, you ought to be informed the reason for your arrest, and once there's sufficient evidence to lay a charge, the charge ought to be laid. And then you're brought before the court for a prompt hearing in terms of dealing with bail, and you can get bail for murder now if it is your case is strong. And however, in Canada, one has a right to not just a prompt hearing, but a prompt trial. We don't have in our constitution any provision that speaks to having a prompt trial process. So the trial process may be delayed simply because of all the other administrative difficulties. The court doesn't feel forced or prompted to start a criminal trial. There's another angle in the delay, Rondell. When we have preliminary inquiries, and the preliminary inquiry may take 2 years to begin, very often accused can't afford a private attorney. They have to turn to legal aid. That process of appointing an attorney by way of legal aid is not a simple process.
Most likely.
When it is you retain a private attorney now, the private attorney may be inundated with other matters. He may want to start the matter, he can't start it because he's busy doing 4 and 5 trials. By the time we get to the trial process, we could have situations where there are mistrials simply because the trial process has begun, witnesses are available, but in the offering of the evidence, witnesses' memory fade. They say they can't recall the statement that they gave 10 years before. They can't recall the details of the statement. They step out of the line of the statement and they're giving contrary information contrary to what is in their statement. So it really stifles the criminal process. It stifles the criminal justice process. It stifles the wheels of justice. So if you find a witness now saying that he can't remember, and he can't remember material things that touch and concern the commission of the offense, then simply put, the judge may be in a position where he has to make a decision concerning whether the prosecution's case is strong enough. You may have a no-case submission at the end of the prosecution's case where the defense attorney gets an opportunity to examine the evidence, and he says to the court, listen, the evidence here is weak, or if it's not weak, the evidence is not, there is no evidence, because the witnesses, if they haven't been killed in the time frame, they died naturally. If they haven't died naturally, they're unavailable because they have not been acquainting themselves with the evidence. They're too timid to come to court. Sufficient time has passed. They're frustrated, and simply they lost interest. They're disinterested. Yeah.
And you can't really force someone's memory.
So criminal trials are frustrated all the time.
And let's change the discussion to the notion of joint enterprise. Right. We have heard it. I mean, I know obviously lawyers know what it is, but in terms of the layman explanation, give us what is exactly is a joint enterprise in the context of criminal law.
Right. Well, let's look at very briefly the Pennywise situation. That very popular situation in the minds of everyone.
Yeah.
In as much as the matter is potentially before the court, there are areas that we can touch on. That offense that allegedly took place, right? In terms of the context of what is carried in the media, what it clearly reflects is that there were more than one persons involved. 4 persons met their demise. Those 4 persons were alleged to be involved in the actual robbery. They were responsible for the death of 2 security officers and the injury to a third. Had they survived and had they been held, then they possibly may be looking at a murder charge and an attempted murder charge on the person that survived. Unfortunately for them, they're in another place. They've met their demise, but there was a survivor. The survivor, his vehicle was involved in the commission of the offense, a Nissan X-Trail. The investigation that followed simply reflected that he became a person of interest. A person of interest is not a suspect. A person of interest is somebody who may have questions to answer in relation to what has happened. Your vehicle was found to be involved. Unless you have a reasonable explanation to explain how your vehicle came to be involved in that, then the natural inference is that you offered your vehicle.
I know they said that he was kidnapped. Well, not kidnapped, so the vehicle was hijacked or something like that.
Right. So that was his explanation.
Yeah.
It's a natural inference that if the vehicle belongs to you, if it is the certified copy carries your name and it was used in the commission of offense, then you may be involved in some way. So joint enterprise involves a conspiracy by a number of persons to commit a criminal offense. And the conspiracy involves an agreement among the 4 to 6 persons where they came together and they planned an operation. So if it is in interrogating an individual, the owner of the Nissan X-Trail, the police are of the view that having spoken to him, he is involved in some way. They need to extract out of him whether by way of confession or by way of information coming from him or whether he was involved or not. If he exercises his right to silence as anyone may in a situation like that, then the difficulty the police have is where do we get evidence to point him to the incident? Let me put all of this in a different way.
What about, obviously you have, warrant for going through the cell phone conversations, etc.
So what the investigator can do in this instance is simply, the cyber unit would take control of his phone. They would examine the contents of the phone. They would listen to the conversations he would have had, because in their liaison with the mobile network, CSTT, Digicel, they would be able to listen into conversations he would have been having. Under the Strategic Intelligence Act, we have the software and the spyware in order to go into conversations and dialogues persons have. So if it is, they check his phone and check the conversations he was having and listening to the conversations. If it is, he is carrying conversations about committing an act, about being involved in something criminal, about planning an operation. The data extracted out of the phone, even WhatsApp messages and text messages, all of that could be extracted from the phone, and it could link him to the incident. So therefore, he may not have a leg to stand on. The fact that he's now in the free world may insinuate that nothing of that scientific nature was found. But joint enterprise involves not just the persons who pull the trigger, or not just the persons who break into the store, not just the persons who shoot, who assault, who rob, who steal. Joint enterprise involves the people behind the scene, the people who procure a criminal offense by supplying a gun, by supplying a car, by driving you to the crime scene, waiting for you while you go in there and do your thing, and then you come back in the weekend and drive off with you. So
and they are more like accessories. We call it accessories. So
if it is you drove a vehicle and you drop a man off, you may have procured the offense. You encourage the offense. If it is you pick up a man after the incident, and you provided transportation, you may be seen as an accessory after the commission of the offense. So you have accessories and aiders and abettors before the commission of the offense and after the commission of the offense. Sometimes people who provide the intelligence, you may pick up the phone and call and say, Farid Ali now is on Gattaca Street, that he should be exiting the building in 15 minutes. Yeah. A man turns up and guns me down. You're guilty for murder. You will carry culpability, liability, and blame because you've contributed in some way. So joint enterprise involves just about everyone who may have contributed in whatever small way, but a material way. And without your input, the commission of the offense may not have been achieved.
Indeed. Farid, it's always good to have you here. It's always good to hear your knowledge and also your interpretation of the law, but unfortunately we're out of time again. Yeah. But I want to thank you for coming on this set and explaining that in very much details, and I'm sure our audience will be appreciative. So thank you so much, Farid Ali.
It's a pleasure to be here.
Indeed. Guys, it's a wrap. You have been watching Strictly Legal on WESN Content Capital with my guest, Mr. Farid Ali, attorney at law. Of course, you can stream us as well, and you can watch our replays. And of course, Strictly Legal with Ronda Donowa podcast. Before I leave, I'll leave you with this. If you cannot do great things, do small things in a great way. Have a good week. Good day. Bye.